So as we get into and try to deal with those individuals who do want to take advantage of the system, if you will, it is important to do a little quick FMLA refresher. Obviously, when we talk about those who are trying to abuse the system, it is important that you do understand your obligations to employees who are not trying to abuse the system. And, of course, understanding your obligations so that when someone does take advantage of you, you can say, I don't have to do that, and here's why. So we'll just do a little FMLA refresher. And the FMLA was passed in the Bill Clinton administration, his first term, and it was in response to the, the concerns that employers were not providing protected leave to employees who may need leave for good reasons. Actually, the United States was one of the last industrialized countries to pass a statute giving job protection to individuals who may need leave for various reasons. And, of course, the FMLA Medical Leave Act sets forth some very specific reasons as to why someone might be entitled to job protection for various leaves. In addition to family leaves, and we talk about the bonding purposes with the child, there's also very specific reasons why an employee might be entitled to leave for various medical reasons. So we deal with the eligible employees, and, of course, when we talk about eligible employees, it is important to understand eligibility requirements, and eligible employees must have worked for you at least 12 months, and that is not seniority date. And when we talk about the 12-month period, it does not have to be consecutive, so we look at any time that an individual has worked for you in the last 7 years to determine whether they have worked for you for 12 months. Now, you might ask yourself, the question is, where did that 7-year period come into play? And that was actually part of the most recent regulations with regard to the DOL's interpretation of the statute. When the FMLA was first passed, the 12-month requirement, basically all it said is it need not be consecutive. It did not discuss how far back we would look to determine whether someone worked for you for at least 12 months. That was very problematic for employers, and the Department of Labor did listen to employers in saying that we can't go back in perpetuity to try to figure out how long someone had worked for you, but they put the 7-year requirement in there to protect those individuals who might